Good afternoon. I'm Ari Schwartz, and this session is how to navigate. It says how to navigate, but it's only supposed to be one how to. How to navigate cybersecurity regulations in a post-Chevron world. We have a great panel actually here for us for today. At the far end is Jamil Jaffer from Paladin Capital Group, and I'm allowed to say the Scalia School at George Mason as well. And then we have Raj Day from Mayor Brown, and we have Wei Chen, who's the Chief Legal Officer at Infoblox. Really looking forward to this panel. So this is the legal law track. We were curious how many lawyers are here. Well, that's a good number, I guess. Yeah, that's and how many people know Chevron and Loper to some degree? Okay, so then we can, I feel like we can kind of go through it pretty quickly, because we just still want to do the overview for people that don't know, so we're not spending all our time on the background, and we'll come back to this slide so you know who we are at the end. Okay, so let's briefly talk a little bit about, well, let's skip this one. Okay, cybersecurity regulatory landscape. So as we know, we have a sectoral patchwork so that the regulations in general are done each by sector in the space. We have some sectors that are more regulated than others, with financial sector probably being the most. And this is in the U.S., obviously, not to be too centered in around the world. We can talk about around the world if we get questions about it later, but we're focused on the U.S. today because it's where Chevron makes a difference. And then, the agencies, what we end up having is that the agencies take, often if there's not legislation specifically, not regulation specifically on cybersecurity in their space, they take advantage of existing legislation or regulations around privacy, safety, or consumer protection and write regulations around that. Am I missing anything there? Any of our legal experts? I should also say I'm not a lawyer, and I am asking the moderator asking the questions of the lawyers sitting at the table. So then the law before Loper Bright. So we have, there were a lot of challenges, going back to the 20s, 30s, and 40s around the powers of the agencies. And again, you're going to have access to all of this in the RSA library. So while I'm flying through this, you do have access to this. You should already have access to it, but you will have access to it later on. We just have too many slides to get through to be able to have the conversation. But we want to make sure that we have all the background for you, which we hope will be helpful for you in the future. Then came Chevron, right? And folks will remember that in Chevron, it was a case between Chevron and the NRDC, where the courts said that there should be deference given to administrative agencies' interpretations of the statutes. So if there's not information there to fill in, the agency can fill it in as long as they're doing it through the APA rulemaking process and have a strong history of how they went about making that decision and how it's tied into the goals of the law. And really became the pillar of administrative law since 1984, and held strong, and then slowly got chipped away. Moving forward past that, you had the cases like Meade, where you needed to have other pieces of this. That Chevron was step zero, but then there were other things that Congress said that they had to delegate. And then we have some of these other cases where if the statutes, if the regulation is ambiguous, the agency and the agency analysis is entitled to weigh, a court can defer to the agency's interpretation. And then you had agencies must have clear congressional authorization for rules that implicate major questions. Am I missing anything there in terms of things you guys want to highlight? So that brings us to last year, when the Loper Bright decision came down. It was the true end of Chevron deference. I think in some areas we had seen it chipped away far enough that there was a lot of questions still remaining every time a regulation was put into place. But in this case, we saw And it was a fisheries case, and there was another one as well, right, that is tied into this as well. But that basically said that we needed a very strong background from Congress in order to for the agencies in terms of the agency rulemaking. They must the federal courts must use every tool at their disposal to determine the best reading of the statute to resolve the ambiguity. We're not relying on the agency as the main source anymore. We're relying on the law and the courts as the first main source, and then we rely on the agency as the back of that, because the agency is also all they can do is interpret the law. One key point that I want to get at here as well, which will come up, which is important down the road, is looking backward, right? The court specifically said we're not going to redo all of the regulations that have ever existed in this space. We're going to have we're going to give some deference to past regulations. We're looking at this going forward, which is important for some of our discussion later. And the interactions with other doctrines. I'll leave this up. Anything you want to comment on here? On Loper Bright? Okay. So with that, we're gonna talk about this. I want to have it be more of a conversation, so I'm going to go back now to the slide of the pictures of all of us, so you can put your faces to the name. And then we're going to turn this part on the future of Loper Bright into more of a conversation. So, lawyer friends.
Recovering lawyer.
Recovering lawyer, exactly. I'm the opposite of that. I work at a law firm, but I'm not a lawyer, right? So I'm the opposite of a recovering lawyer. Looking at how cybersecurity regs have been done in the past, are there concerns or thoughts on how we're going to do cybersecurity regs in the future under Loper Bright? You want to start, Raj?
Sure, I'll give it a start. And as a practicing lawyer, I guess that makes me the addict in this crowd as a recovering
Right.
lawyer. Okay, so I think historically the thesis has generally been cybersecurity regulations that involve technology need to be flexible, and there's been a hesitancy to have very specific guidance that will be outmoded over time. So I do think something like Loper Bright really requires a reset in the paradigm, because it's going to require some more specific guidance from the Congress, which historically has neither been forthcoming, and I think most people don't think there's the aptitude there to do that. So to me, that is probably one of the big questions coming out of this.
Jamil, as a former congressional staffer, how do you feel about the idea of that these laws are going to be able to cover this whole space?
Well, look, I actually think this is an interesting and important area. It might actually suggest that in areas that are rapidly moving and evolving and flexing, that maybe neither the regulatory state nor Congress is best placed to put in place strict rules that make it hard for the private sector to operate. You look at how successful we've been in the United States when it comes to technology innovation, and then you compare it to Europe, and what you realize is the US has been so successful and so innovative and moved so quickly precisely because we haven't created a massive regulatory footprint on top of it. Just look at AI. Well, look at any metric. The top 10 technology companies in the world, all headquartered here. Every major LLM, save maybe one, maybe two, built in the United States, right? And why is that? It's because Europe adopts a regulate first, innovate second mentality. We adopt an innovate first, maybe regulate, maybe we don't mentality. And so the court roping in the regulatory state and saying, hey, Congress has got to do the job, and Raj being right that it's hard for Congress to change the rules fast in an evolving area, maybe that's a win for American innovation, and maybe we should be thinking about, hey, how do we regulate or write laws better to deal with the moving dynamic of cybersecurity, and saying maybe the laws in the regulatory state aren't the way to deal with cybersecurity.
Yeah, I 100% agree with that. I'm a lawyer who is specialized in reading long text Now I'm taking on a operational role, so that I'm the one who is gonna have to like work with our product security team, trying to fix the CVEs in our products. And what I have discovered is, for example, when we're trying to get FedRAMP certification, or we're trying to deal with incident response, you have a lot of men in the middle, middlemen trying to comply with these regulations that is more compliance driven and not operation driven. And a lot of times these people, including myself, right, including the GRC folks, are well-intentioned. However, we're taking a lot of time from the product engineers, from the security engineers, actively trying to diagnostic like what's going on and trying to patch the problem. As a company that, the only member of the panel who actually owns a P&L and owns the budget, one headcount in my position is one headcount less for the security position. So that is something that, I think the regulation needs to take care of. And I have some thoughts but I'm sure that you're gonna ask some follow-up questions.
Yeah, I mean,
that
in terms of the
tease out.
follow-up, I mean, both Yue and Jamil, you're talking about the space of technology regs, right? Is there something different about cybersecurity, though, that we've seen with cybersecurity regs, because it's national security oriented? I'm a former general counsel for the NSA here, so he'll have an opinion on that. Is there something different about cybersecurity that we've seen that distinguishes it from technology, or is this all technology that we're really talking about, that we're going to see this changing?
Well, look, I think that the one thing that is unique about cybersecurity that might make it particularly hard to regulate is how fast the adversary moves and how fast the technology changes, right? You look at all the companies that are on the floor of the RSA conference today, they're vastly different than the companies that were there last year and the year before that and the year before that. That's because the attacker is changing. And so the idea somehow that Congress or the regulatory bodies would be able to keep up with that in any sort of effective manner, I think is chimeric at best. Now, you might say to yourself, well, actually, but then there has to be something useful the government can do, right? The government's got to be able to do something useful, right? Well, how about this? How about the idea that if the government lined up the things it wants? The government really wants information sharing. It really wants incident reporting. It really wants access to your network so it can help you identify threats and help you defend against them. The government's not that good at defending its own network. Query whether it can be that good at defending your networks, but whatever. Let's pretend that was an important thing. How much you effectuate that? Well, one of the best ways to do it would be to line up what the government wants with what CEOs want, what boards want, and what lawyers want. And that means getting your incentives going in the same direction. Well, imagine if the government said to you, rather than using the regulatory stick and beating you down and threatening you with fines and penalties and the SEC coming after you if you don't share information, what if we said, for every piece of information you share, we'll give you a tax break? Or even better, for every piece of information you share, we won't regulate you based on that, or we won't hold you liable once you share that information. Every lawyer in the room, every operator in the room will be running to share information with CISA and with DOJ and with the FBI and with the NSA. They'd be begging for more opportunities to get you in their networks and work with them and collaborate. Why? Because you're protected from liability, you're protected from regulation, you might have some monetary benefit. Now all of a sudden you're all rowing in the same direction. The problem is today, for decades, we've talked about how defending the nation of the cyber domain is a shared responsibility. Yet, when things don't go well, the government comes in and wants to whack private sector over the head, whack investors over the head, whack boards and lawyers over the head. And what do you expect the reaction to be? We're not going to share with the government. We're not going to work with you. We're not going to collaborate. We'll do as little as possible and wait as long as possible. And then when you force us to do it, we'll do it begrudgingly. It's no surprise this is the scenario we walk into.
I'll pile on and then turn it over to Wei. I agree with Jamil that this area is unique in the sense that there's an active adversary, unlike other regulatory areas. So I do think it's more dynamic than other tech reg. And I do think it's important to align the private sector and the government. And there was, a nascent attempt to do that in CISA when it was first passed with some of the very, very, very limited liability protections that are basically non-existent. But that was a thesis that kind of got watered down.
Who drafted that thing? That original version.
Yeah, it was somebody. I don't know who. So I agree with both of those. I would say, I'd be curious if you agree with this. I think I saw that at NSA, and you see it in any business, the thing that hurts operators the most is fragmentation of what the rules are. And I think the big question is, which direction are we going to move in now? there is a thesis to be made that I think with more interpretive authority with the courts and less with an agency, you could see lots of conflicting decisions that take time to resolve. They can get resolved. The courts are designed to resolve that, but it takes time. So it's not really helpful if you're a national company and you have one rule in the Second Circuit and one rule in the Fourth Circuit, and you kind of have to get it resolved. So there's a risk of that. I think there's also a risk of other legislative bodies rushing to fill the void, whether that's state authorities or on a global scale, other countries. There's no reason it has to be connected, but that's just the way the world works. Once one regulatory authority gets hampered, others kind of rush in. So I don't know how that all turns out, but I do think we need to keep an eye on how fragmented it is for operators.
100% agree. The fragmented regulation regime work, like this patchwork, is not good for anyone. And I think that everybody recognizes that, and everybody is trying to fix it. However, the incentive is not there for everybody to coordinate and put one side of framework together and say, like, we all agree with that. I think, like all technologies, yes, like cybersecurity is unique, but it's also common with all of the other technology. In terms of innovation, actually helps resolve a lot of these issues. However, the current regulation is going down, from the agency, is going down to the very prescriptive line item requirements. And that, in a way, it's helpful because a lot of the unsophisticated parties actually don't know where to start. So, at least you have a roadmap of where to start. However, what it hurts is these very effective, scalable, cost-effective, emerging technology that has no place in that framework, right? So we're talking about like quantum, quantum resistant encryption. We're talking about AI. Like I just saw a demo of a company use generative AI to automatically detect vulnerabilities in containers and third-party components and fix it, like with a click of a button. Of course, I thought it's snake oil, but when I saw it, I was like, oh, well, I'm sure I need to manually validate that before I click the button, but it is possible now. With respect to what, protective DNS, encrypted DNS, these are things that, the government already know. They're going about and try to put a free service together for the schools, put a free service together for the states. However, nobody knows about it, right? And you have all of these evangelists or guardian of cybersecurity, like the insurance providers, like the DFIR firms, like these consultants. You go to them and you say, hey, what should I do? And then they're like, oh, get an MFA and EDR. I'm not saying those are the wrong choices to make, but it's not the right choice for every single entity, right? For a school that has like 5,000 students that click on phishing emails from time to time, EDR may not be the right solution, right? A protective DNS is like $15,000, protect all of your student bodies. Maybe that is the right solution. So, but the guardians of the security have no discretion to do that, because if you do that, if I approve something like that, I'm going against the norm. And I'm going to be penalized for not following the herd, even though that following the herd doesn't make sense. So this one-size-fits-all kind of regulation framework really doesn't work for every single entity.
So we've heard a lot of ideas about where things might go, et cetera. Where do we think the first challenge is going to be in this space? Like we have seen, the water sector already challenged, right, and they've won. Even before Loper Bright was around, we've seen several other sectors as well challenge, particularly around TSA. So TSA's work in this space and successfully win some of those cases and get changes to the regs. What sectors do we think are going to be next in terms of the challenges, or what kind of challenge do we think is going to, if we don't know exactly what sector, what kind of challenge do we think are going to come based on
we put some money and betting going on here?
Yeah, a little bidding. Well, I think maybe one place you might see it is, there's a to both Wei Chen and Raj's points, there's a multiplicity of regulations on incident reporting, right? The SEC's got one standard, the FTC may have another, if they establish one. You've got CISA with another that's from statute, right? And so you might see, a proactive company say, look, we don't know what we're supposed to deal with here. We don't know what we're supposed to report to whom. It's a mess. We want some clarity. And this might be a place for the courts to come in and say, well, A, do you or do you not have the authority to regulate this domain, right? If you have the authority, how far can you go, and how much interpretive authority do you have under Loper-Bright, particularly the SEC with its the way it uses its broad language to interpret its authorities. And by the way, the same is true of the FTC. The way that the FTC uses its very broad authority over certain deceptive trade practices and acts to go after companies in all sorts of domains, including in the cyber domain, I think will be interesting. And that might be where you see, I think, one of the first challenges, and one that actually could make its way all the way to courts. We've seen them in the past.
Yeah.
They haven't gone.
In fact, CERCIA is interesting, the DHS one you mentioned, right? It's in process now.
Right.
And we know in the comment period, the authors of the statute said you're doing it wrong, right? They wrote a letter in saying that you exceeded your authority,
Yeah.
right? How do we think that that's going to play itself out in that case? And are there other areas? I don't know, Raj.
I put my money with Jamil. I think SEC or FTC probably for a couple of reasons. One, they're big juicy targets that have just been talked about. Two, you have to think about where regs are in the pipeline, to your point. So certain things are off the table if they've already been Chevronized, and if they haven't been yet, they're in the zone. And then third, it'll be interesting to see if something like CERCIA regs actually make it out of the chute, because this administration is taking a different view on the regulatory front. Something like Loper-Bright actually may provide a way to shortcut the APA process to rescind a rule even when it's in process. So it might not even make its way to be able to see a challenge. So there really is a pretty narrow window of regs that could be subject to this, and so I'm with you on those two.
Yeah,
Safeguards rules and SEC disclosure rules. Sorry.
Yeah, so for those of you who didn't know, CERCIA was, like I was 24 months ago. It's the incident reporting regulation that is currently in the rulemaking process for critical infrastructure. I think that itself would require DHS to self-police themselves a little bit. And I'm not surprised, the reason why it's still not coming out is because they're doing that process right now.
Well, that goes to my next set of questions, actually, which is what are we seeing from this administration in terms of putting out cyber regs, and how are they changing? I mean, they would obviously have a different point of view just from the nature of the politics of this than the Biden administration did. But what is the Trump administration doing in terms of looking at the cyber regs that we've heard of right now? Wei, do you have thoughts there? Or?
Yeah, of course, there's the executive order that calls out, I think it's called Fostering Innovation Through Deregulation, and it calls for 10 for 1. If you put out one regulation, you have to remove 10 regulation. And for those of you who that sounds familiar, it's very similar to the 2017, the first Trump administration's 2 for 1, but clearly 5 times
Inflation.
X. Inflation, exactly.
Tariffs.
One thing I do want to highlight is I'm delighted to see that there's this new program called FedRAMP 20X. It's still currently in the public comment period. I personally think it's heading into the right direction. It's aimed at removing some of the unnecessary process and paperwork, and essentially, if you think about it, it's more like, hey, regulation no longer in text and narratives. Regulation is actually in code, right? So how do you operationalize and then have an automated validation of each of these points? It puts all of these incentive to comply in the hands of those people who actually know what they're doing, right? Actually doing it. So, for example, within companies like ours, is it me who is, or like our CISO who are responsible for keeping our product safe, or is it our CTO, like the chief product officer and chief technology officer, who is in a better position to keep our product safe, right? So I think that just moving the focus from focusing on paperwork, every FedRAMP, process requires thousands of pages of paperwork that time going back and forth. And now if we could create an automated validation process, people are going to necessarily focus on procuring the money for vendors like what I just saw, can create some automated remediation or validation. I think that's a very pleasant change to see.
Other thoughts? The other question I wanted to ask actually goes to something that Raj said earlier, which sort of ties into some of this, which is, as we see a void from U.S. pulling back on regulations, does that international and state changes and efforts, do we begin to worry about that and having actually less harmonization and regulation than we currently do? I remember when I was in government, like the Norwegians actually came to us and said, like, you don't understand how influential your rules are. And I was saying, yeah, I mean, we know you take them and you pull out, you adapt them, and like, we're the first movers. And they're like, no, you're not the first movers. We translate your rules into Norwegian, and we take the cover off the thing, and we put our cover on, and that's our law. So, like, that's not going to be the case anymore, obviously. It hasn't already been the case to some degree in the last 10 years or so, 6 years or so, let's say. Are we worried about the diversity of regulations that could come and what that impact on business will be?
Yeah, well, I mean, look, I think we should be worried. We should have already been worried. I mean, the European footprint, whether it's, GDPR, which, by the way, for those of you who care about privacy or about cybersecurity, GDPR, useless, right? I mean, actually worse than useless. It makes us feel like we're doing something. It's not actually protecting your privacy. It's not actually protecting, cyber. It's actually making cybersecurity worse, right? And they're going after big American technology companies. There's a handful of cases where the targets have not been in big American technology companies, but that's about it. It's just a way for the Europeans to come after who they see as market competitors to juice their own economies, which of course hasn't worked because they regulate first and innovate second. But GDPR or DMA or DSA, I mean, you name it. Time after time, the Europeans are regulating ahead of us. AI, right? The EU AI Act. And there's a perception, though, in a lot of places in America that, well, we're behind Europe when it comes to regulation. We need to catch up, or we need to get ahead of them so that then we can set the basis for the regulatory framework rather than them. And I think that's the wrong approach for two reasons. One, just because we want to regulate doesn't mean we should, right? We should regulate when it really matters, right? We should regulate when the market hasn't worked, where incentives haven't worked, and then we need to regulate, and then we should do so in the narrowest, most focused way possible. That's just not the European approach, not the European mentality. They're never going to go along with that. And so trying to convince them to come around to that is probably the wrong answer, or they won't learn until we continue to dominate in the technology innovation space, which we have and we'll continue to. So I think at the end of the day, the answer is we've got to demonstrate that our methodology is better and then hope that they adopt it like the Norwegians do, rather than trying to play their game and just do a slightly less bigger regulation so then they might come on board with ours. I don't think that's going to work. I don't think it'll create innovation. I think it'll actually hold us back.
I mean, I think I agree with Shamil in the sense of the game doesn't work as it's currently being played, but I think there's no doubt in my mind the lesson we've learned after GDPR is unless we figure out where we want to go, we will be following. And I don't actually care if we're following other than it doesn't seem to be a very effective outcome, to your point. So CCPA follows along after GDPR. If we're constantly in that mode of effectively adopting what in your perspective would be lowest common denominator, worst regulatory regime, if that's true, that can't be the right answer either. So to me, that is the real dilemma here because it's not only coming globally, it's coming from states as well. So clients, financial services clients dealing with DFS regs, that's not great for them either because it brings them, their entire global operations effectively have to become compliant with DFS regs. So the answer to my mind has to be figuring out what we want the model and go forward, but it's complex and
So I have a theory.
yeah,
I have a theory.
Of course,
So,
I
so,
know you.
in when it comes to the federal government and states, right? The federal government, at least in areas where the Commerce Clause applies, can choose to sort of take up the field, right? Sort of, preempt state law by saying we're going to occupy the field, we're going to set the rules, we're going to take state law out. Now we can't do that internationally except we might be able to. So first of all, there's a theory that if we want to preempt state laws, we've got to be as broad as the broadest in order to do it. That's just not true.
Correct.
We could adopt a very small, very light touch regulation and just say we intend this regulation to preempt the entire field. We can wipe
That's
out.
just easier to do before the state law exists.
Well,
and
fair. Okay,
Congress
fine.
acts
Great.
too
Let's
late.
do that. So let's
Yeah.
move first. Let's do it light touch, and then let's say we're not going to accept any state regulation on the state level. And then when it comes to our friends in Europe, well, look, they put our companies to the test of, hey, if you want to compete in Europe, you got to comply with our laws. How about we say, look, you want the benefits of all the U.S. economy and all the U.S. innovation gives you, you can't comply with crazy European laws. It would be a nuclear war, right?
But
It'd be
if you say
U.S. preemption. But by the way, if there's an administration that might do it, it's the one in the White House today.
The tariffs don't look so bad.
I know, right?
I'm
Exactly.
gonna let that sit. I'm gonna let that sit with people rather than challenge it right now, actually. And the mics are open if you guys want to come up and ask questions. One thing, which a good question for Wei here is, what should companies be doing in the chaos? What can they do to preempt this? And I'm specifically thinking of, a standards-based approach like you guys have taken with 881. I don't know if you want to talk about that. It's, focusing on like where we should go. Right?
Absolutely. So what do companies do, right? We all know that, all these regulations of different industries, and we ourselves is not in the regulated space. However, all of our customers are, right? So it makes helping them complying with the regulations very challenging, because there's one set of regulations for banks and one set of for telecommunication, one set for TSA. All of these is slightly different. And that is why that we are focusing, from a privacy perspective, we are focusing on GDPR, right? That is has become the highest watermark, and everybody is trying to. And I'm still trying to digest why GDPR is not helping privacy. So in the lawyer's mindset, I need to see operational evidence of it's actually not helping with privacy. But that I'm making a mental note that I will do that research. But from a cybersecurity perspective, I think NIST is doing a good job in terms of setting a standards. There's the CSF, there's the 800 series. These are not things that that you absolutely have to comply with, otherwise that they will come and fine you and whatnot. These are best practices that you could look at and say, okay, this is the framework. If I don't have the expertise, at least this creates a baseline for me to get started. The thing that's challenging is we all know if everything is important, nothing is important, right? So I would hope the new agencies and then the policymakers. I actually wanted to get your guys' point of view, because you guys were all at one point lawmakers and policymakers. The Loper Bright case necessarily requires statutes to become a little bit more descriptive and more technical, right? Would the policies and the lawmakers have the appetite to become a little bit more technical themselves?
No, I don't think so.
And would that be a good thing for us to see?
I'm not saying I want that outcome. I'm just saying I think that's the reality.
Look, I think obviously you're relying on staff in part, right? And you have an increasingly technology-savvy staff. That doesn't make up for it. But then you also have outside parties that you talk to. You talk to industry groups. You talk to companies. You talk to people from your district. You talk to technical experts. The law regulates in very technical areas, right? Patent law is obscure, right? There are a lot of areas of law that are very technical that don't require generalist lawmakers to be deep in that space. We have this, I do think we have sort of, as cybersecurity practitioners and technologists, we do have sort of this fetish that because we work in zeros and ones, everybody, including our lawmakers, and everybody has to be as smart as we are. And if they're not as smart as we are, we sort of look down upon them and say, well, they can't work in this space. They're not good enough. If a lawmaker looks at their phone and is like, can you help me with my iPhone at a hearing where we all mock them, right? It's the truth is, lawmakers for 200 years in the United States have made laws without being experts in every area of the law, and yet they make laws and we've never had a problem with it. Why is it so problematic in technology? Why do we feel we need to defer to a bunch of unelected bureaucrats in the regulatory state to do it? I'm not saying good or bad. I'm just saying it doesn't seem like the obvious answer when we don't do it in a million other areas.
Well, I agree with you on that one thing that they shouldn't have to be specialists, but I don't think it's because we think or people think they're smarter than the legislature. I just think if they don't actually understand the details, there's too much room for lots of different stakeholders to gum up the works. So
And that's not the case in the regulatory bodies? I mean, literally,
this
literally
isn't-
regulatory capture is a thing.
This is not an argument for why it should be the regulator. This is just why Congress isn't going to do it. So this is not about where it should be.
That's
This is
fair.
just
Okay,
a reality
fair.
statement.
Yeah, it's on there, it's now on Congress's.
Now it's on Congress's plate. That's right. That's right.
And the thing about
Well,
patents,
can-
but
can
sorry,
we have
Art,
a- go ahead.
one last thing, patent reform is like, that's the holy grail. That took like 20 years. So I think that is a good example of, that's like the counterexample, but it's the only one and it took like 20 years.
Yeah, so I kind of agree with Wei Chen. I'm struggling to understand why GDPR is useless, based on what Jamil said. From my understanding, it was brought about with the intention of protecting personal data with global scope. I think the problem is that US tends to have the wild, wild west of regulations when it comes to protecting personal data, or historically so. And so where enforcement is happening, because US is one of those territories where it's big companies gathering all that data, the natural progression of that is that the exposure is going to be higher. So I'm not really getting why it's US is being targeted, or the US companies are being targeted, and GDPR is totally useless when all it's seeking to do is give persons just a little bit more control over their personal data.
So-
Struggling.
Yeah, so well, let's talk about both pieces of that. I think two different pieces, right? One is American companies being targeted, but let's talk about the latter piece because Wei Chen raised it as well, right? This question of whether, in fact, our privacy is better served by GDPR, right? So let's talk about it. The biggest providers, collectors, users of personal data are big technology companies, right? And third-party data brokers, right? How's their stock doing over the last 7 years since GDPR's been passed and been in effect and gone into effect? Better or worse? Are they making or losing money? That is their primary way they make money. They're all doing great. What does that tell you? That tells you the data is still being collected, still being sold, still being marketed. So if it was going to solve all your privacy problems, we'd at least see a partial downturn. The markets would pay a price. What's in fact happening, right, is that we're all clicking through.
But their
Sometimes
practices are different, though.
What's
know
that?
that their practices are different. They've been slapped on the knuckles a couple times, like
They've been
Facebook,
subject to
for example.
billions of dollars in fines by the
Yes,
EU.
but they've now changed the practices, and there are certain principles that are now being utilized and acknowledged even by them, which is why your regulations are also following GDPR. That's following OECD guidelines that basically produce the principles on which GDPR was built. That's transparency, data minimization. Those principles are living out now. Yes, I totally agree. There are still dark patterns. US companies find ways to circumvent and still go and get people's data. There's a privacy paradox. I agree with all of that. But there has been, since 2016 till now, there has been a change in the way that big tech has been acknowledging that they are collecting personal data, and there is a responsibility on them to be a little bit more transparent. So I think the change, I have seen a change.
I mean, do you feel like put aside whether they're more transparent, you know more about your data. Do you feel like you have more privacy today, really, literally, than than you did before GDPR?
I'm more informed.
Okay, you're more informed. Who feels today, post GDPR, that you have more privacy than you did before GDPR when it comes to your data? How many people? Raise your hands. How many people think you have about the same or less?
And how many of you think it's because of GDPR as opposed to the changing state of the world and technology? Right? So
I don't
hate
think
to say it, I'm not sure
GDPR
it
is the
comes down to that.
reason for that. I think it's
Yeah.
the progression of technology.
Yeah, so I think the reality is, I mean, look, I don't doubt that it has some notional effect. It makes us feel better, right? We all get to click through a million different website links and reject and accept, and sometimes I'll turn it all off, sometimes I won't. But the reality is that that's just causing me a lot of time and a lot of waste, and it's costing us lots of money to comply.
So what's
Hundreds
the
of millions of dollars,
alternative?
billions of dollars worldwide to comply. At what real tangible benefit, right? We know a little bit more. Great, I like that. Don't get me wrong, I like that, right? But are we really feeling more private for all the costs imposed?
So what's the alternative? Just
We've
no
gone off on a little
regulation?
bit far on a tangent now. I mean, it was entertaining for a little bit, but I think we need to move on. It's more entertaining than the Calm app, which has a sleep story of someone reading GDPR, by the way. If you want to go to sleep really quick, click on someone reading your GDPR. Okay, go ahead.
Hi. Hi, Leopold Wildenauer with the Information Technology Industry Council. I really appreciate the discussion around, the need to kind of counter some of that regulatory fragmentation. I feel like that was one of the core themes that we discussed today. Just wanted to make sure that everybody in this room, I'm sure you all are aware, but that everybody's aware that there's currently a request for information out for comment right now that the Office of Management and Budget has put out, where they're soliciting input from the public to say what are some of those duplicative regulations. First of all, just wanted to make sure everyone was tracking that, and then second of all, I'd be curious in hearing from the panelists what some of the specific areas are, in addition to information incident reporting, where you all might look to comment and weigh in on that RFI.
I'll throw one idea out there, which is, I mean, we've seen it from the financial sector that they can be asked to do 6 different audits, basically doing the exact same thing with the audits, and question as to whether you can get them to all use the same audit multiple times.
It'd be great if it was the exact same thing, but the problem is it's not the exactly
Same
that's
thing.
the problem.
Well, but
right?
but if you can get it to be reciprocal, so that you're only doing a few extra
Of
things
course,
rather
of
than
course.
and use the base of the same one, so that you're not redoing a lot of the same controls over and over again. That's just one example within this particular sector. Go ahead.
Yeah, one example I'm aware of is just reporting to CISA, and then CISA is going to help protect us. Great, right? But reporting to 28 different state AGs, and so that they can put the big hammer on us, and yet they can't do anything. And then in the meantime, that people like me have to go bug our product team and security team, trying to collect information while they're trying to prevent the bleeding, stop the bleeding and prevent kick out the bad actor. Not a good use of the time, right? There needs to be some kind of state level harmonization and reconciliation of looking for information from CISA or from one central resource, and then figure out what they need to do.
And look, cybersecurity writ large, right? I mean, do I need to do the NIST framework? Do I need to do FedRAMP? Do I need to do CMMC? Is it one of the million state regulations? What do I need to comply? Do I need to comply with what the FTC said last week? In a proceeding where they used unfair and deceptive trade practices to go after a given company, Wyndham Hotels or whatever it might be, right? Or some small drug company. I mean, what is the rule I need to comply with? And if I comply with that rule, can I tell everybody else I've solved everybody else's problems? Will every other regulatory agency leave me alone as I comply with the one that's in my area or my state, right? That's the problem, right? Put aside, trying to get everyone to have the same regulation, right? How about just, if I comply with my sector-specific agency or whatever the thing is, right? Or the one ring that rules them all for me, can you just let me be with everybody else, right? Do I have to comply with the SEC's rule? How do I know what the SEC's rule is? When will they tell me what's material and what's not? Oh, when they make it up. Okay, great. I'll figure it out down the road. I'll get whacked in the meantime. I'll try to do the best I can. If I don't do it right, they'll come punch me in the teeth, right? I mean, this is not, if your goal is to get national level cybersecurity, and remember, we're being attacked by nation states. This isn't there's a lot of ransomware actors out there, a lot of criminals and whatever, but at scale, we're being hit by Russia, China, Iran, and North Korea. And until we recognize that we're not gonna be able to do this with the government doing it on its own or the private sector doing it on its own, but collaboratively, we're not treating it like it's collaborative. We're treating it like you're the enemy. You, industry, are the enemy. We, government, are going to tell you how to do it better because we're so good at protecting ourselves in-house. We're going to tell you how you ought to do it. And by the way, we're going to give you 48 different rules. You can comply with one. That's not good enough. Comply with all 47, and then we'll still come after you.
Last 2 questions, okay? Go ahead.
Thanks, Kim Nan. Great panel, thanks. I'm from Europe, so I'm not going to touch on GDPR. And I'm a mathematician, so I think I'm allowed to ask maybe a silly question. Isn't the whole legislative process, building laws and stuff, totally unsuitable to deal with the technology we are looking at? And I give you an example from Europe. The AI Act doesn't even speak about generative AI, because by the point it was started, it was not there. So the question is, what is the alternative if you agree or if you think it can be done? So how can you move it forward?
I still think it's a worthwhile endeavor. We can disagree on what the end point is, but I personally don't think the answer can be, unless it's perfect, it's not worth trying.
No,
Yeah.
that's clear, but
I think Jamil, who I disagree with on a lot of stuff, including many things he said today.
He didn't say everything. He did not say everything.
But I agree with you on this. I mean, like if we could start with something that's like a framework from the beginning before people start regulating, and then you're like picking off, you're like responding to other people's regulations, et cetera, and building up that, a stockpile of stuff when it makes it very difficult because you have to get more and more specific. If you could have a framework that works, that relies on some kinds of standards from the beginning, we're going to be in better shape than if you end up like, where you end up with all this.
Yeah, I think this might be part of the answer, right? Which is that I think you're right that our system of laws and regulations today are not well suited to a rapidly moving environment like we have here. That doesn't mean, to Raj's point, that sometimes you're not going to have a law or a regulation. There may be times when the market fails and incentives don't work that you need this, right? But if you start with a broad-based theory, particularly one that's driven by the experts in industry, like the NIST framework is, right? And you say, okay, if you comply with that and you can demonstrate you do that and you're audited and it works, we're not going to come after you. And if we want to make a rule later, we'll apply it prospectively and not retrospectively, and we'll only do it at the minimal level necessary. That might be the beginning of a process that gets you to a functional, usable, process that can actually be effective. Now, how do you convince all our allies around the globe to do that, right? That's a much harder question. And I don't know the answer to that.
And how do you end up with an enforcement regime that isn't like totally jumping back and forth, where sometimes it's done very strictly and sometimes it's done more broadly? That's a little bit tricky.
I think we all agree that uncertainty is both the worst thing for business and for privacy.
Yeah.
It really is. It doesn't have to be perfectly certain, but there needs to be some greater clarity for sure. That's right.
Yeah, I'm Jeff Fenton with Lockheed Martin. One of the obstacles in front of Congress in the several times it has considered a national breach notification law or a national personal information privacy law is whether or not to allow a private right of action. Suppose instead of being ambitious on a law like that they could address a narrower issue of having one definition of a personal information breach and one standard across all 50 states plus the District of Columbia, Puerto Rico, and the U.S. Virgin Islands for treatment of notification, time frame, and practice. And then at the federal level, one regulation regarding incident reporting of material information that impacts national security or critical infrastructure in terms of an incident, rather than having a defense federal acquisition regulation supplement DFARS regulation, a federal acquisition regulation, an SEC requirement, a CISA requirement, and I think there might be one or two others at the moment.
Here. Yeah, we probably need one set of rules. But also, I think, that gentleman talked about, hey, with the evolving development of technologies, how can we have one set of rules that can keep up with the time? We do that all the time, right? Today's technology versus, the technology 20 years ago is vastly different, and people need to focus on the outcome. Is the outcome keep people safe, right? You can be safe in the airplane or in the submarine or, just sitting in front of your computer or slip and fall in a retail mall. I mean, all of those things we need to start thinking about. In terms of incident response, incident reporting, how does that map out to the final outcome, which is to keep our information safe? Right? That correlation needs to exist for this whole market to work.
No, I mean, I think that's exactly right. I mean, I think at the end of the day, one standard, right, one rule, one law, whatever it might be, is probably helpful, right? But the question is how expansive does it need to be? How detailed, to your point, does it need to be? Does it need to solve all the problems, right? One of the problems in Congress is you have a collective action problem, right? You've got to get, 51 members, 60 plus members of the Senate, right, to get through cloture, right? You need to get, a majority of the House, and then you got to get the president to agree, and all these people have to agree on one text. To get everyone to agree on one text without giving everybody a little bit of the things they really care about and they want is what makes the legislative process hard. It's also why, by the way, our default rule in this country is not the law, right? It's the private sector driven capitalist model. And by the way, it's worked pretty good in software. Like I know that as cybersecurity experts, we all think it's really important that somebody ought to do something in cybersecurity because we feel like we're not getting the backup we need from our CEOs and our CISOs and our boards and everybody else. But the truth is, like, maybe the answer isn't somebody needs to do something. Maybe the answer is let's drive it from the ground up. Investors, like, Paladin, we just got a group of about 18 investors together who believe in strong protections of security, strong cybersecurity rules, strong, only selling to American allies, not selling to China, Russia, Iran, North Korea. And we got investors to agree that we're not going to invest in companies that don't do that. This is a private capital-driven effort because we believe our capital and the capital of our limited partners is better delivered and better deployed and earns higher returns when our IP doesn't walk out the back door to China, when we're not selling technology adversaries, when we're defending the very capital system that allows us to invest. And that's how you drive real change. You don't drive it through some law passed by 51 members of the Senate that don't have technology expertise. Private capital drive results.
Let's end there. Thanks to the panelists. Really appreciate their time. I also wanted to, since it came up here, I'm not surprised it did. I'm on a panel on Thursday at 9:30 on regulatory harmonization. We have 2 people from the EU that will be there with 2 Americans. Should be a really good panel and very interesting. Thanks.
Thanks, Eric.